Mr. Arnold.
I'll start with round one and Paul and Constance test, as my friend calls it. Can I start with 3 points by way of background to that test? First is that no particular words or phrase need to be uttered in order to create a trust. I'll give you references without turning them up. The old case of Richards and Delridge, cited by Lord Justice Bridge at 27 G2H in the authorities bundle, and Sir Colin Rymer in Ong and Ping at paragraph 58 of the judgment, which I'll show you when I also have to show you 59 in a little while. Secondly, the question of whether or not a trust has been created may have to be determined by reference to written words, spoken words, conduct, or critically, as my friend accepted in answer to Lord Justice Arnold this morning, a combination of the two. And to link that to words in the judgment in Paul and Constance, Lord Justice Scarman, bundle page 26G, the key words are "from what is said or done," and Lord Justice Bridge at 27H, the key words are "the deceased had done something which was equivalent to declaring himself a trustee," etc. Third background point to the test. Given that what we are looking at here is not unlike Gani, which is the common intention of two parties, but it is what intention the set law, quote unquote, evinces. To talk about imperative versus precatory language isn't very helpful because people don't normally talk to themselves. As Colin Rymer put it, helpfully I submit in Ong and Ping, which you have at tab 15, and if you kindly go to page 2, bundle page 224, my friend relies on the formulation of what the reasonable person would be satisfied of. So in paragraph 59, what the reasonable person, the conclusion was that the reasonable person would be satisfied, dropping to the third line, Mrs. Lim's actions evinced an intention by her to subject the house to the trust of the settlement, and that she thereupon made a valid declaration of trust in respect to the house. So that's a practical example of Lord Justice Scarman's "from what is said or done," or Lord Justice Bridges "done something equivalent." So in the context of this case, evincing an intention to subject something to a trust is probably a more helpful formulation in terms of how the test works. Having made those points of background, we would very much stand by the submissions of our skeleton argument at paragraphs 39, 40 and 42. And if I might, however, deal briefly orally with 41.1, there's an important point here in relation to what is or is not a decision of fact. And this came up in a number of questions to my learned friend this morning. And the key point essentially is that if words being construed are oral rather than to be found in a document, then the evaluative decision about them is a question of fact, unlike construction of a document, which is, as it were, all encompassing or inclusive, when of course it's a question of law. That is when, of course, it can reasonably be argued in this court that this court's in as good a position to construe the document as the judge at first instance is. That's not this case. Now, in Carmichael, the point is made, this is bundle, page 57, with a rather erudite exposition by Lord Hoffman drawing on lectures by Lord Devlin in the mid-50s about the whole origin of the troublesome distinction between questions of fact and questions of law. But to pick up on 2049, the conclusion, the first three lines at A, thus, reference to the historical bit, the rule that the construction of documents is a question of law was well established and has been carried over into employment law. Then between B and C, and the facts of this case, he said, he thought that the Court of Appeal pushed the rule about the construction of documents too far. It applies in cases in which parties in turn intend all the terms of their contract to be contained in documents. On the other hand, it does not apply when the intention of the parties, objectively ascertained, has to be gathered partly from documents, but also from oral exchanges and conduct. In the latter case, the terms of the contract are a question of fact. And also side-marked is 58 at the very bottom through to 59, which makes the point about subsequent conduct. My respectful submission, that is clearly equally equivalent to questions concerning whether or not a trust has been created, and indeed that point was specifically touched on in a case of Hilton and Cosnea, which we'll need to look at later, so I won't ask you to open it twice, but the reference is paragraph 12 in the judgment of Mr. Justice Morgan in Hilton and Cosnea. So that, in my respectful submission, passage in paragraph 41 of our skeleton argument is relevant and helpful when one looks at questions of fact, what is properly considered, conduct being taken into account, subsequent words being taken into account, and so forth. You've been referred to a total of 4 cases in which the question of whether or not a trust was created, or in the sense I prefer to, declared, Paul and Constance, which in a moment I will go through in a little bit more detail because it leads into the next part of my instruction. If I can deal just in a sentence or two with the others. The case of Ulman Ping concerned what inference was to be drawn from the signing of an incomplete trust document, the trust document with the schedule of the trust property not filled in. So on the face of it, if you limited yourself to that document, there was a trust of nothing, as Sir Colin Rymer put it, coupled with conduct, and in particular correspondence conducted by the putative set law, Madam Lim. So that was what that case was about. I'll come back to it for other purposes later. Wilkinson and North, a rather more complicated case because there are a number of claimants putting their case on slightly different bases. But most of the judgment deals with Mr. Wilkinson, the first named claimant's trust. In his case, he relied entirely on a document. The document described itself as, I think it was an agreement of contract, or a contract of agreement. It had both words in the title. So that was a classic matter of construction. And construction of a document, in accordance with the well-known principles, subsequent statements were simply inadmissible to help in Wilkinson and North. For completeness, 5 other claimants also relied on documents, albeit less formal documents. Same principle applied. And 2 relied on oral statements, but the Court of Appeal took the view the judge rightfully took the view that the words spoken will not have gone any further than the words in the document. Therefore, one didn't end up with a different result from what Mr. Wilkinson had had. Then Hilton and Cosnier, that was a case about the construction of two oral statements. The statements are set out in paragraphs 10 and 11 of the judgment, immediately followed by the passage which I've already referred at paragraph 12. Now, beyond those features of the nature of the cases and what material the court was looking at in any given case to draw its conclusions, beyond that, of course, comparing the results of cases on different facts is not a useful exercise. As this court will be well aware, but if you want an authority for it, it's Sprint Room, paragraphs 82 to 84. So for Paul and Constance, may we go back, please, to tab 2 of the authorities bundle, and I wish to focus, if I may, on the main paragraph on page 27, the main two paragraphs, the last two paragraphs of Lord Justice Scarman's judgment. And having posed the question about was there sufficient evidence to justify the judge reaching that conclusion of fact, and that's the 3 lines above, which do, in my respectful submission, elucidate the point made by Lord Justice Arnold to my learned friend this morning about the bottom 2 lines of 26, treating the basic problem as a question of fact, the very way in which the judge expressed himself in A very much reinforces that point. Now, my submission, one can put in, as it were, 4 side headings here. The first is just by the letter B, where the sentence starts with when. What we have here is the background. The background in this case was, one bears in mind, the unsophisticated character of the deceased and his relationship with the plaintiff during the last few years of his life. Then one has, secondly, the words used. Mr. Wilson submits that the words he did use, and this was the established phrase, "This money is as much yours as mine." Then we have what did those words convey, and that's just by C. The judge accepted the conclusion. He was well justified in doing so, and I think he was right to do so. And then fourthly, we have the other supporting features. And my Lord went through these with my learned friend. The interview with the bank manager, that is dealt with at 23H to 24C. The putting of the bingo winnings into the account, that is dealt with at 24D to E. And the one withdrawal made, that's 24E to F. And in a moment, I'll invite you to apply that analysis to this case. But before doing so, lest the very fact that I make submissions might be held against me, I must first submit that the judge's approach to resolving this case is, on a proper analysis, unimpeachable. First point, that the question for the judge here, where exactly what words were spoken some 17 years before the judge tried the matter, 2005 to 2022, were not clearly established words, unlike on the facts of Paul and Constance, unlike on the facts of Hilton and Cosnier. That was, just as Lord Justice Scarman said, bottom of 26, top of 27 in Paul and Constance, a question of fact. Second, the judge correctly identified in paragraph 3 of his judgment that there was a crucial lack of contemporaneous documents. Contemporaneous, say 2005 to 2007, and therefore he correctly applied the guidance of this court in NatWest and Bilter. He set out the crucial paragraph. I was looking at the right document, which I think is 51 in the judgment.
$52.
52, yes, I'm sorry. 52 of the judgment, and then the judge refers back to that again as 125. That's paragraph 37 where our skeleton argument deals with that. And then he applied the 4 factors identified by this court as the sort of things that a judge who has to fall back on things other than contemporaneous documents has got to work with. And on plausibility, a crucial fact which has not been properly acknowledged at any point in my learned friend's submissions is the judge is perfectly entitled to weigh up plausibility by reference to the competing cases that were put before him. You haven't heard anything about those, my friend. The one time, very conscious, Lordship's appreciated if I'm able to finish this afternoon, but in a few minutes' time, the one slow documentary exercise I am going to go through, if I may, is to show you pleadings and witness statements as to what the competing cases were before the judge, which then explain why he made the findings he did. And if, again, as you find it helpful for me to show you, just by quoting paragraph numbers, this is what happened in Ong and Ping, paragraphs 34 and 49, comparing the relative likelihood of the 2 possibilities. The one possibility in that case was Mrs. Ong had intended to impose a trust over the property in question, and despite the fact that she hadn't filled in Schedule 1 of the document she signed, the other possibility was that she intended to create a trust of nothing. When you look at it that way, the answer, plausibility, comes in to assist. Similarly, in Hilton and Posnier, the paragraphs are 15 and 27. And again, the judge weighs up the relative likelihood of the alternatives in play before him or her. And we seek to make this point in paragraph 51 of our skeleton argument. We set out, paragraph 38 occupies a bit more than a page, but some respects in which the judge duly applied the other factors identified in Bilter, consistency of behaviour, assessment of credibility, and inference from non-contemporaneous documents. So, for those reasons, I respectfully submit that what we say at 46 to 49 of our skeleton argument about the judge applying the correct burden of proof and coming to perfectly proper primary fact findings based on those is correct. Now, before heading into more factual matters, at the risk of immediately starting island hopping, as Lord Justice Lewis, I think, first said, there are some key principles in my respectful submission which I would wish expressly to remind you of to be applied as we go through it. And it can be done by reference to 2 cases, which one is Volpe, tab 22, decision of this court in April of last year. This is was a case where the issue was one of fact, largely primary fact. we see on page 331, paragraph 1 of the judgment, lines 1 and 3, the issue on the appeal was whether the judge was wrong to find that a particular payment was an interest-free loan rather than a gift. So those are the two competing alternatives, gift or interest-free loan. So, says Lord Justice Lewison, unsurprisingly at paragraph 2, therefore an appeal on a question of fact. The particular passage which seems to fit this case extremely well starts on the bottom line of 331. Any trial judge will have been faced with the task of trying to do a jigsaw puzzle when some of the pieces are missing and many of the others do not precisely fit together. Certainly my experience trying to get back on top of this case ready for today and reminiscent of a challenging 11 plus 1 day trial with a great deal of documentation, quite a lot of witnesses. And at paragraph 7, the importance of inherent probabilities or inherent likelihoods stated by the judge and duly endorsed by this court. Then on page 338, on at the end of paragraph 59, a phrase which in my respect was quite apposite here, any judge called upon to make findings of fact in a contested case will have evidence pointing in each direction. And it is a commonplace exercise of the judicial function. He will weigh the competing considerations against each other. Then the next point, well, take points out of order, so I'll just stick with the same case. Sticking with this case, thirdly, so back at paragraph 2, Roman 3, please, on page 331. An appeal court is bound, unless there's compelling reason to the contrary, to assume that the trial judge has taken the whole of the evidence into his consideration. The mere fact that the judge does not mention a specific piece of evidence does not mean that he overlooked it. And for essential familiar point, weight is preeminently a matter for him. 6, reasons will always be capable of having been better expressed. Don't subject a judgment to narrow textual analysis. And the one other point, which I'd ask you to go to sprint room, 2 tabs earlier, tab 20, paragraph 77, and then it will be 84 and 85. The essential point is, at a headline level, the judgment is not expected to set out everything, but it's more than just a point like that that can be rolled out by anybody appearing for a respondent in this court, but it's the reasons why. And in my respectful submission, could I ask you to read to yourselves the citation from Lord Halpern, which occupies most of paragraph 77.
Well, I think you're
Pushing an open door?
No, you're not. It's not a question of open doors, but it's very well trodden ground.
My God,
I think we have this cited to us weekly.
My Lord,
usually by respondents.
Yes. Well, my Lord, if I just simply tell you the particular passage I would say are opposite to the exercise my friend's done this morning is 77 and 84 to 85. This is facing an argument that the judge decided this case on the basis of 3 points, which my friend elaborated near the end of his submission. So my respectful submission, great respect, that submission was bordering on the absurd. Now, to apply the structure that I presumed to apply to Lord Justice Scarman's judgment in Paul and Constance here, in my respectful submission, there is far, far more than the 3 points which my friend acknowledged this morning here. So first, same heading, background. Background here, as found by the judge, includes at least these 3 points. Firstly, that the Thinds and the Gills, and indeed the Caylors, were a close family until 2018. Judgment 9 to 9 sub 2. Second, Mr. Gill had agreed to hold the share capital of another company, Jeeves Investments Ltd, on trust for the Thind children in April 2004. Judgment, paragraphs 11, 79, and 130, Roman 1. And thirdly, within their family at least, there was a family ethos of providing for the next generation. And as Mr. Gill accepted in that part of his cross-examination that I got to conduct, all the grandchildren generally treated as siblings, not just cousins. And this is judgment 9, paragraph 9, sub 7. Second heading, the words spoken. We'll take you to these passages in view of how...
I'll go back to
Yes.
the point that you second made a moment ago, which was other companies held on trust.
Yes.
That, from your point of view, would be a significant element in the overall picture, because as soon as one has trusts of something, then the probabilities in relation to trusts of something else.
Yes, somebody who's declared a trust once is inherently more likely to have done so a second time. In that sense, Lord, yes.
Yes, so you would say that you're entitled on this appeal to point very loudly to the dog that isn't barking, which are the other two findings in relation to those companies.
Absolutely, my lord. And the fact that the judge, who 10 paragraphs earlier in his judgment had made his findings about that, didn't say it all again under the heading of JEL, it is not a proper basis for appeal. In what was a promptly delivered judgment, managing to do it in 140-odd paragraphs, where bluntly many first instance judges would take a good deal more to cover this much ground, the judge isn't... the fact that the judge didn't list out altogether as sub-paragraphs of 140, the points I'm now drawing
Yeah, but I was really, I
attention...
understand, I wasn't so much thinking about the texture of the judgment, but about the implications of the unappealed findings.
Yes.
For the appealed finding.
The unappealed findings of trust we do submit to important. It's there in our skeleton somewhere. I've got the reference, but
as I understand it, you place particular reliance upon the JIL one because it was earlier in time.
Yes, it was about April 2004 to December 2005.
So it's both earlier in time and not that far away in time.
My lord, yes.
Yeah.
And when we come to look at Mrs. Gill's evidence, Mrs. Thind's evidence, which was accepted in respect of both of them, the criticisms you've heard today of her evidence about this one could equally be applied to the JIL. The positions don't, the evidence of is similar nature. Indeed, insofar as it's looking back, it was looking back a little bit further.
Can you just specify whether this point about the implications of the findings in relation to JIL and Simicare is a point that the judge explicitly made, or is it simply one that you're entitled to make in support of his reasoning?
My lord, I think it's the latter.
Right.
Because
it's not. I don't remember, but I'm just giving you the opportunity to point to a point where the judge said, I also bear in mind my findings on the other matter, which I find clearer as supporting the inherent probabilities. He doesn't do that. In
no,
fact.
my lord, he doesn't.
But you might say he was perfectly entitled to do that.
I do say he was perfectly entitled to. He isn't bound to say once in his judgment everything that's bearing on his mind, let alone to say it twice in the same judgment. He said it 10 paragraphs, less than 10 paragraphs earlier.
Thank you.
And my lord, what in a way has given my friend a sort of opportunity to make hay is that the judge did not repeat all the factors that were relevant to this that he'd mentioned once in his judgment already between paragraphs 139 and 143. If you read paragraphs 139 to 143 in their isolation, then one can say, as my learned friend had the bravado to do this morning, he submitted that the judge had made his decision on the basis of the phrase "for the moment," the no capital investment point, and limited reliance on Mrs. Thind's evidence about the December 2005 conversation. Well, that assumes that anything that the judge doesn't expressly rehearse for a second time, once he's put the side heading JL in on page 135, can't have been weighing on his mind. And there are numbers of passages in the cases that your lordships hear from weekly from the respondents, which repeatedly make the point that's not an appropriate approach. It might be an appropriate approach if, as on the facts of NatWest and Bilter, the judge delivers the judgment 20 months after the trial, because then, contrary to the usual principle, this court will no longer make the assumptions that the judge must have had matters there in his mind. But here the judgment came out very promptly, and absent an exceptional circumstance like this, the judge is not to be criticised, and let alone is his judgment to be impugned on the basis that anything that isn't under the heading above 137 didn't weigh on his mind. It's an entirely false basis of criticism, in my respectful submission. So my second heading, mirroring Paul and Constance, are the words spoken in December 2005. So if we start at paragraph 80 of the judgment, the judge there set out his summary of Mrs. Thind's evidence of the conversation in December 2005. My friend gets as quick as he can to the last sentence, where the phrase is, "Once again I treat this evidence with a degree of caution." But that was exactly the same as he did about JIL, penultimate line of paragraph 79. He treated her evidence of that with a degree of caution. Treating it with a degree of caution because she wasn't sitting focused on that conversation throughout, but that she was moving in and out of the room, is not the same thing as rejecting her evidence. And it is, in my respectful submission, a rather unfair point about something she said elsewhere in her evidence about her memory of this. I would ask you to look at the evidence that supports what the judge said at paragraph 80, which is to be found in Supplementary Bundle tab 9 at page starting at page 193. It's paragraphs 38 to 44.
This is her witness statement.
This is her witness statement. And our Scales argument gives some references to cross-examination as well. So 38, I draw your attention to some key phrases. So I've seen from this morning, the court will pick these passages up very quickly. Jazz and I first spoke to my dad about Laurel's nursing home in December 2005 at 8 Park Crescent, the Thinds' then home. 39, I remember it came up in conversation that it would be a good idea to leave a portion of the business, that's her phrase, rather than shareholding, for the grandchildren as a whole. I cannot say who brought the topic up. At 41, I had some input into the conversation. I made a comment about the lounge at the Laurel's nursing home. The judge specifically refers to that. 42, second line. I know at the end of the conversation I understood that my dad was going to loan some money towards the purchase, and a third of the Laurel's nursing home could be held by my dad for all his grandchildren. It was clear that the money from my dad was a loan. There was no discussion about my dad having any involvement in the business as partner or anything like that. Then the point she particularly remembers, don't tell the Kaylors about this, or Mr. Kaylor will ask for a loan too. And then, I am going to take a moment to emphasise this, paragraph 44. My recollection of this conversation is good. I couldn't say what exact words were said in the conversation, but I can recall the topics of discussion, the outcome, and who was present. Now, if you go forward to page 249, please. As Practice Direction 57AC applied for the witness statements in this case, there has to be a certificate, confirmation certificate confirming compliance. The third paragraph, on points that I understand to be important in this case, I have stated honestly how well I recall matters and whether my memory has been refreshed by considering documents, if so, and when. And that is because Practice Direction 57AEC, perhaps just give the references unless you'd like it open, it's paragraph 4.1, which is at page 543 to 4 of volume 2 of the current White Book. Then there's the annex of best practice against practice direction, which points out that witnesses are to be told about the court's approach to the true nature of memory and so forth. And as we note in our skeleton argument, a matter the court was told about at the pre-trial review, as well as at the trial, is that Mrs. Thind acknowledged that she was going through the menopause and it was affecting her, and it in some respects affected her memory. The Equal Treatment Bench Book, which is at the back of the bundle of authorities, expressly acknowledges that that is a known feature of the menopause, and at the passage that my friend cited, where she referred to having brain fog, that was in the context of being asked about a particular document, pretty much out of the blue. And in my respectful submission, the judge's findings about Mrs. Thind at paragraph 86, coupled with the proper attention in her witness statement to compliance with current standards in respect of witness statements on key contested matters, is all relevant material to the judge's approach to this matter, where, yes, he used the phrase a degree of caution at paragraph 80, but that in no way, in my respectful submission, either equates to a rejection of it or undermines the general finding of paragraph 86, and is therefore perfectly proper evidence of words spoken. So it's in that context that one should fairly read paragraph 140 of the judgment, where the judge's phraseology at that point moves from degree of caution to limited reliance. But again, he goes straight on, absolutely properly, to consider plausibility against the background of what are were the competing cases. So the third of the headings, plausibility and inherent likelihood, that's touched on in judgment paragraphs 140 and 142. And then other features in favour of the finding. The monies advanced in 2006, £133,000, were advanced as loans, not capital. Judgment 139, 140 and 145, and my friend acknowledged in his oral submissions this morning, but for the purposes of this appeal, it's accepted that those monies were paid by way of loan.
Well, on ground one.
Yes, on ground one, where I am. Yes, of course one would. Yes. Secondly, closely linked, the £108,000 which was repaid was not declared to HMRC as income. Judgment paragraph 139. And thirdly, long before relationships soured, this is compensation in 2010 with shares ultimately vested in Mr. The one share in the company ultimately vested in Mr. Thind in 2012. He agreed a third time to act as trustee of what's called loosely a family company. That's judgment 20 to 21, 81, 90, and 132 Roman 2. And should we need them, then there are the three respondents' notice factors as well. My respectful submission, all of that is highly relevant to whether or not this case gets anywhere near one where the findings of fact of the judge, be they primary or evaluative, would fall to be overturned. And there are particular factual examples of what I think Lord Hoffman described as the penumbra of underlying matters that don't actually get mentioned because the judgment can't cover everything, but are all going on in the judge's head. Now, there are three facts in my friend's skeleton, two of which he developed orally, which he relied on for the purposes of ground one, pointing against a trust. And as I cited Volpe, paragraph 59 a few minutes ago, the trial judge having to deal with cases where the factors that point each way is not a surprising or unusual matter. Now, firstly, the learned friend relies on the cross-option agreement, and you saw it this morning, the reference is Supplementary Bundle tab 32 at 410. So this was a document signed 4 years after the trust was fully constituted by a transfer of shares in November 2007, and almost 6 years after it was orally agreed in December 2005. And the judge deals with this and the circumstances surrounding it quite fully. Firstly, Core Bundle 110, paragraph 25, page 110, I'm sorry, he sets out key features of the option agreement, paragraph 25. He then deals with the genesis of the document. And this is important, the suggestion that what he says later on involves internal inconsistency within the judgment. The circumstances in which it arose, Mr. Thind's evidence, particular concern being about Culdeep acquiring shares after Mr. Gill's death. At this point, Mr. Thind discussed this with Mrs. Thind, who shared his concern. It wasn't progressed for another year, and then Mr. Constantine from the same firm was asked to draft an appropriate document. 2, the limited documentary evidence shows, we haven't got this in the supplemental bundle, the trial bundle reference is E3.1, 321 to 3. A rudimentary form, a very fair description of it, was sent to Mr. Thind to complete to enable St James's Place Partnership to draft the document. The form did not make any reference to trusts or make provision for those. And neither Mr. Woolhouse nor Mr. Constantine gave evidence, and there was some debate in front of the judge whether there was any significance to that against one party or the other, as the firm had acted both for Mr. Gill on the one hand and for Mr. Thind on the other hand. In the end, there was no basis for it being an adverse inference being drawn against either side. Then, it's put shortly here, Mrs. Thind's evidence is she left this to her husband, but she shared his concern about what Culdeep might do after Mr. Gill's death. Now, in view of what's just about to come, I will ask you, please, to look at the relevant passage in her witness statement, because it explains why, it shows an obvious reason why the judge would have expressed himself in the way he did in the passage I'm about to show you. So this is supplemental bundle tab 9, page 209. It's paragraphs 87 to 90 of Mrs. Thind's witness statement. And paragraphs 87 through to 89 cover the ground of what happens if Dad dies, Culdeep getting the shares, lack of trust in Culdeep, and so forth. Then paragraph end of 89, Jazz and I knew the time had come to address this issue. Our pension advisor, Mr. Woolhouse, advised us that a way to safeguard from the shares falling into Culdeep's hands. Jazz told me he instructed one of Chris's colleagues to draw up a cross-option agreement. I was not directly involved with this, but I always understood that it meant my shares, the shares my dad held in trust in Jeeves Estates would never pass to Culdeep. So that, in a way, provides the answer to Justice Jackson's question this morning about what evidence there was about what was trying to be achieved. So that is entirely consistent, going back to the judgment, with 26 sub 3. 26 sub 4, Mr. Gill's evidence, obviously also objected in no respect, that Mr. Thind brought it round and signed him up. The one obvious difficulty with that is that Mr. Woolhouse witnessed Mr. Gill's signature on the document, and Mr. Povey, the bookkeeper, witnessed Mrs. Gill's signature. That's apparent on the face of the document, and you can match the address to the witness statement and so forth. So then 27, read objectively, 2011 state options, there's nothing about any trust in Mr. Gill's shares in JEL. However, I bear in mind that what matters for the purposes of these proceedings is what conclusions, if any, I can draw from this document as to the state of the mind of each of the parties in 2011. So, as to the witness whose evidence was basically accepted, I've just shown you the relevant passages, paragraphs 87 to 90. That's 15 pages of cross-examination about it. I'll give you simply the reference. It's day 5, at transcript pages 95 to 110. Then there's an interesting phrase in the judge's judgment on the consequential hearing on this matter. So this is supplemental bundle tab 16 at paragraph 9. Basically, he's dealing with the class closing rules point. But in paragraph 9,
I'm sorry, that's supplemental
bundle
bundle 16.
tab 16, page 382.
Thank you.
Sorry, Molly. So here, this is my learned friend relying on the option agreement for a different purpose, unsuccessfully trying to persuade the judge that it operated as a sufficient contrary intention to displace the class closing rules. Line 4, secondly, as I indicated in my judgment, it is by no means clear that the parties really understood what that option agreement meant. So that phrase, when coupled with 25, 26 and the evidence I've just shown you, makes complete sense. So the judge then picks up on the topic at 73 and 74, and I would respectfully submit, if anything, takes a relatively harsh view from my client's point of view about the statement of the evidence here, in particular not finding it credible that Mr. Thind signed the document without reading or understanding. The impression I formed of Mr. Thind, he takes great care of documents which he reads as important. And to be fair to my friend, he acknowledged that actually that was a mistake because it was Mrs. Thind that signed the document, whereas that finding was about Mr. Thind. Then 74, which is the more sort of looking at it perhaps objectively rather than subjectively, the 2011 option makes very little sense. If, however, he believed it's beneficially, then it would make more sense. And so, taking 25 to 27, consequentials judgment, paragraph 9, 73 and 74 all together, when you get on to paragraph 141, it's readily understandable why at the end of the first line the judge uses the phrase tends to suggest. I bear in mind that the 2011 option agreement tends to suggest that Mr. Thind regarded Mr. Gill as being a beneficial owner of the shares. In my respectful submission, the trial judge was the person by far best placed against the background of this whole case. I mean, seeing a bit more briefly in Mr. Gill's case, all the relevant people other than Mr. Woolhouse in the witness box and cross-examined, and knowing the whole background, the trial judge is the person best placed to form the conclusion which he did, for the reasons set out in Sprint Room at 77 to 81. In this context, it's probably as convenient a moment as any to make sure that I give our answer to a question that Justice Jackson asked this morning about what exactly was the judge's finding about JEL. In my respectful submission, that can be seen from these paragraphs, 18 of the judgment, setting out the competing cases about the terms on which Mr. Gill holds the shares in JEL. 80, which we've just looked at, his summary of Mrs. Thind's evidence on the topic, coupled with 86, of course. Then 138, where he identifies, not criticised, the two propositions that the Thinds need to establish to make out their case. And then, of course, 143, and he effectively repeats this in the consequentials judgment, the same page as I've already showed you, page 382 of the supplemental bundle, paragraphs 8 and 9. In my respectful submission, the cross-option agreement was one of the matters which tended to support the other view, and not my side's view, but it was a matter properly and quite fully analysed by the judge, and it did not ultimately, in his best placed judgment, outweigh the other matters.
Could I just, as you're going through the evidence,
Yes.
check with you these references?
Certainly.
This is to do with the question of what was the state of the evidence about a conversation that must have taken place in order for the shares to have ended up in different hands subsequently. And this is the conversation we've dealt with already in Supplementary Bundle 193 with what Mrs. Thind said, paragraph 38 and onwards, which you've taken us to. So I just launch from there.
Yes,
it's a feature of this that because such serious findings were made in relation to the documents, that although Mr. Thind gave evidence at quite some length, at least to look at his statement about this, the judge in his judgment doesn't refer to that at all. I mean, I'm extrapolating that that's because of his findings about other aspects of that witness's conduct. But if we look at 104 in the supplementary bundle, we find quite a long equivalent description from him of the same conversation described by his wife through paragraph 79 onwards and ending around 84, in which he's essentially giving the same account, namely loan for grandchildren. Now, and so it's another feature of this judgment that the judge actually appears to be willing to place weight on the wife's account of this,
Yes.
but he doesn't explicitly say anything about any weight to be attached to the husband's account of it, but the husband was saying the same as the wife.
My Lord, it's a point that's actually was troubling me in my preparation for this, whether I should be throwing in references to Mr. Thind, where he also gives supporting evidence.
Well, you don't need to, because as you pointed out to us a moment ago, the judge summarised Mr. Thind's account of the same discussion in paragraph 18, subparagraph 2. And as my Lord points out, the substance of the two accounts were quite closely aligned, as the judge plainly recognised. And although he did not regard Mr. Thind as a reliable witness, on the contrary, he said he was not a reliable witness, he did regard Mrs. Thind as a reliable witness, and therefore subject to caution, as you've acknowledged, he accepted her account of the conversation, which matched his.
My Lord, yes. And the irony is that what did for Mr. Thind, in terms of the judge being able to rely on him, was the equivalent of the false alibi put up by an innocent man, that in respect of the trust of JIL and Simicare, which the judge found did exist, the documents the judge found that Mr. Thind forged were in support of that part of the case. And the net result is there's a lot of evidence that appears. My Lord Justice Jackson just pointed out in one example where effectively the same or a very similar account of the matter has been accepted, but it's been accepted on the basis that it's come from another mouth.
Yes. So this finds reflection in the framework of the judgment, namely that it appears in summary as being his evidence at 18.2, but that when one comes later in the later part of the judgment to the treatment of the witness himself, there's no mention of it at all, and one can imagine why. And then so far as Mr. Gill was concerned, I'm sure there are multiple other references, but supplementary bundle 28 is just a bald account of a purchase for himself beneficially at paragraph 10, and I'm sure there are many other parts of the reference and transcript which the statements and transcripts which could be looked for.
Well,
that was what the judge was left with.
Yes, as it happens, my Lord, on the topic of capital investment or not, which I will not be stressing this tax case, I will briefly do it. That is the one where I will show you both pleadings and witness statements for both sides on each issue, because once you see them, I hope it will assist you in finding whether there's any proper ground of criticism of the way the judge addressed the issues which the judge addressed at all.
Thank you.
My Lord, secondly, of the three factors my friend relied on for ground one purposes, comes the email at the 3rd of January 2018. This, you saw that this morning, the reference is tab 34 in the supplementary bundle. The judge deals with this at paragraphs 97 and the first sentence of 98. And again, whatever else can be said, it can't be said that the judge overlooked it. On the contrary, the judge quoted the bit of the email which my learned friend likes, and then gave the conclusion in the first sentence of paragraph 98. This is one of the things pointing the other way. Mr. Basu gave evidence about this that was less helpful to my friend and was cross-examined about it. But I mean, consistent with my own case, which is to say that it's the judge's job to evaluate all this, it doesn't seem that, unless you ask me to, that rattling off endless references to evidence, all of which the judge has taken to have had in his mind, will really advance matters. So then we can deal with the third point. It's maybe something that contributes to whether I finish today or not. In my friend's skeleton argument at 30 to 31, he relies on the supposed difficulty in ascertaining who the beneficiaries were. This is the grandchildren class closing rule, as one of the reasons that pointed against a trust. He did not develop that point orally at all. So I think in those circumstances, although it's a point that we would fiercely contest, if I may give you just a couple of corrections, I would point you to our skeleton argument, if insofar as the point's in play at all. So it's paragraph...
My Lord, if it assists my learned friend and your Lordship's ladyship, we do not pursue that point on this.
Well, that's very fair, thank you.
That is extremely helpful. I need to even give you the two additional references on that basis. I'm grateful. My Lord, although it is not the order in which we've included it in our skeleton argument, thinking about it and having heard my friend's comments this morning about the interrelationship of the different grounds of appeal, it strikes me that logically, perhaps the respondent notice points come now, because ground one against me is there isn't sufficient evidence to support any finding that the Paul and Constance test is satisfied. If a friend wins on that, he doesn't need grounds 2 and 3 and so forth. So perhaps logically, the respondent's notice points, which I can deal with shortly, come in here, but because we say if necessary, there were additional points. In skeleton terms, we pick it up at 83 in our skeleton argument. And if you are poring over the legal validity of these points, without reading any of it out now, we have attempted in the way the grounds are set out at tab 4, pages 32 to 34 of the core bundle, to set out quite precisely exactly why we say this material is admissible, on what basis, etc. To deal with it shortly, and in fairness to the members of the family overall, Mrs. Thind was not the only member of the family found to be capable of telling the truth and having told the truth, but both of their sons, Avnish and Jeeves, were also found to have been honest witnesses at paragraph 87 and 92, as was the father-in-law, Satnam Singh. Now, so far as Avnish is concerned, it is supplemental bundle tab 7, page 71, for one paragraph 7. Strictly, it's for one sentence. It's for the last sentence of paragraph 7. So he is the eldest of Mr. Gill's UK resident grandchildren. Two Kayla children were older in Canada. They clearly had a close relationship and so forth. And in paragraph 7, last sentence, my granddad told me more than once that for the Laurels nursing home, a trust arrangement had been put in place for all the grandchildren. Now, the judge deals with this at paragraph 87. He deals with matters from cross-examination. You need to check it later. The reference to that, I won't open it up now. Supplemental bundle, tab 28, page 403 to 404. And on the basis, the judge says he couldn't recall the exact words used. He acknowledged he didn't understand what a trust arrangement was. Then this, although he was an honest witness, his evidence did not materially assist. Now, in my respectful submission, we are entitled to submit, as we do at paragraph 86 of the witness statement, consistently with what we say about the general approach to judges' evidence, that if the court is lured by my learned friend's submission into reopening the analysis and evaluation of the various bits of evidence, whether or not there was enough to support his finding at ground one, then to say it did not materially assist does, in my respectful submission, go so far. It's a matter of weight, certainly. His age, how much he understood at the time, but to say that that evidence from an honest witness of a clear admission against interest more than once by his grandfather is, in my respectful submission, something that should have been given some weight.
If only as corroboration of what his mother said.
That is so, it's not.
Yeah.
But I think you can, in a sense, take these points quite quickly, but not either because we're likely to accept them or we're likely not to find them helpful, but it's really, I mean, you're saying that if there's source for the goose in going outside the judge's findings, then there's some source for the gander to be found in these references that you can take us to.
Well, exactly so, and that's, we say that rather less elegantly at paragraph 83 to form our skeleton argument. Very shortly, the Ranjit-Venning message, tab 10 of the supplementary bundle. It's important in view of the point my friend made this morning. At page 255, you have a proper hearsay notice, much seldom observed in my experience of these days, which correctly identifies the document, the witness, gives the reason outside the jurisdiction, and the exhibits, relevant exhibits at page 257. There only was one trust for the grandchildren in play, so insofar as this text message is of any help, it's of help on this issue. Now, my friend said this morning, well, of course, the court didn't hear cross-examination about this. Well, there's a perfectly straightforward reason for that. When you're served with a hearsay notice, CPR 33.4 gives you the right to require the witness to be produced for cross-examination. Two other witnesses gave evidence for cross-examination. The other side never served a notice asking to cross-examine her. So it's a bit rich to complain in this court that it wasn't tested by cross-examination. Again, we readily acknowledge that, particularly with hearsay evidence, there's always an issue of weight around. But it is right to point out that what the judge said at paragraph 114, my friend put forward as what the judge said about this, and there's nothing wrong in it. It's actually what the judge said about every bit of evidence that he hadn't otherwise commented on. Paragraph 114 is not about this WhatsApp message. It is about the considerable amount of additional evidence to which I was referred. So the judge hasn't specifically made paragraph 114 about the WhatsApp message, and we made that point in the skeleton argument. Thirdly and finally, Satnam Singh's evidence. As the judge put it, the adverb clearly comes in, was clearly an honest witness. Certainly, anybody who'd been in the courtroom when he was called would have come to the same conclusion. Now, he gave evidence about what his son told him in 2006. Now, my friend makes the point that Mr. Thind's evidence was rejected as unreliable at court, but the dispute flared up in 2018. On the judge's findings, which I'm stuck with, of course, he made the terrible mistake of seeking to bolster up a true case about two trusts by forging a document for each. I'm not going to begin to endorse that or say it's not too serious or anything like that, but the fact that he reacted in that way to the dispute that blew up in 2018 is no reason why 12 years earlier he should, when the families were very close, as the judge found himself, he should have told his own father some fabricated story about a trust in respect of the JEL shares. there was evidence of a similar conversation about the JIL trust. Of course, now that that's been found, that's a bit by the by. Now, this is a case where Mr. Gill's case was that there was never any trust arrangement in respect of any of these three companies. In effect, he's saying this whole case of trusts is fabricated. He used the word fabrication at one point in his witness statement. So that is why evidence of what Mr. Thind said to his own father in 2006 was relevant to rebut that fabrication in terms of admissibility in the relevant sections of the Evidence Act, and in terms of its relevance, consistency of witness behaviour, being one of the Filter and NatWest factors. So, for reasons in our skeleton arguments 89 to 91, we say that those three items were entitled to some weight. I then come to grounds 2 and 3, and I will skip what was mentioned to me earlier about what was brought here as weekly, some of what I prepared, but as to ground 2, Maloney Friend's skeleton argument correctly accepts, in the heading above paragraph 41, that that is a matter of primary fact. That's the capital investment point. And in my respectful submission, there's quite a good comparison with the issue in the Volpe case, gift or interest-free loan. Here it's interest-free loan or a capital investment, as I'll show you in just a moment. Ground 3, in his skeleton argument, Maloney Friend sought to submit that his ground 3 points were evaluative fact. He didn't particularly pursue that distinction orally. We submit, for the reasons in 61 and 62 of our skeleton argument, that in reality ground 3 is primary fact 2. And under ground 3 there are really two headings. There's what was meant by the oral statement for the moment, and then there's the little basket of 5 bits and pieces, which if ever there's island hopping, that was it, the bundle of 5 little points of fact picked out for ground 3. So ground 2 and the attack on the judge's conclusions 139 and in particular 145, the friend's going to rely on this one again on ground 4, as he indicated. And so may I show you firstly what the judge, how the judge actually formulated the issues before him in his judgment. So at paragraph 34, where he's dealing with the 133,000 and the 280,000. So this is 7 lines in, I think, but there is a dispute as to the nature of these payments. Mr. Gill says these sums were his capital contribution to a joint venture. They say these were loans. And the background, as you know, there have been other personal loans in the past. At paragraph 137, last line, albeit it is disputed whether these were loans or investments. And paragraph 145, that's the resulting trust paragraph, they alone provided the capital for these companies. Mr. Gill's only contribution was by way of loans. Well, and very understandably, given what you have not shown, my Lord Justice Jackson raised more than once with friends the question of, does it matter? Does it matter? Is the judge drawing some sort of false dichotomy here? Now, I will do this as quickly as I can with your assistance. But can I show you, please, firstly for the 133,000, then for the 280,000, what the parties' cases were that had been placed before the judge. We can start in the core bundle, please, at tab 17, page 146. Paragraph 4 is dealing with Jeeves Estates, the particulars of claim refers to the annual return which showed the 100-200 split. And so picking up at the top line of 147, this coincided with the claimant investing 133333 and the first defendant investing or alleging he was investing 266667, partly to finance the purchase of the said company, since which time the said company has operated as a quasi-partnership between the claimant and the first defendant, now added by re-amendment, under the joint venture described at paragraph 12. So if we go to 151 for paragraph 12, it's quite long, but if we pick up, I think it's 8 lines down, there's a sentence that starts, the claimant and the first defendant in those discussions agreed they would purchase the property and run a business therefrom as a joint venture, and that the claimant would have a 1/3 stake therein, and the first defendant would have a 2/3 stake therein. Now, if we can go to tab 18, next tab, page 168, for the defence, and this is only because we're going to look at the reply to the defence. So this is 4.5 and 4.6 in the defence. 4.5, around the 6th of June, that was the date of the purchase of the property went through. To fund it, Mr. Gill lent Jeeves Estates 133,000, Mr. and Mrs. Thind lent Jeeves Estate 267,000. Paragraph 4.6, except that it's admitted that Mr. Gill and Mr. and Mrs. Thind each left Jeeves Estates money as set out. Second sentence is denied, no quasi-partnership, etc., etc. The reply, unhappily, is in the other bundle, the supplementary bundle at tab 1. And the reply to that is to be found firstly at 4.3, page 6, paragraph 4.3. First sentence makes the point. Subparagraphs 4.5a and b and 4.6, which you've just seen, are denied for the reasons given at paragraph 12. That's the one that I've already shown you. And then if we can go forward, please, to page 9 for paragraph 11 of the reply. So other paragraphs, I won't show you them, but if you want the reference there, tab 18, 176 in the core bundle. But picking the second sentence of 11.1, the claimant did not offer to lend money to JEL, didn't agree to hold his interest on trust. Instead, he invested in the joint venture. Now, for the evidence in support of that, we can go on still in the supplemental bundle to tab 4, page 28. It's paragraphs 10 to 12. 10 deals with putting the 133,000 in. It was agreed I'd have a 1/3 stake. The first defendant to have a 2/3 stake. I paid my share of around 133,000. And jumping to paragraph 12, at a time I can't precisely remember, the first defendant suggested he and I should withdraw our original investment monies, notwithstanding we had previously agreed its outstanding loan should be repaid prior to either of us taking monies. I received my initial 133,000. That's the affidavit which he signed in support of an injunction application. But his trial witness statement is tab 11 at page 264. Sorry, starting at 263. The relevant paragraphs are 18, 20 and 21. So 18, second line, the shares in JL were issued to me because of my investment in the joint venture. My 1/3 shareholding being equivalent to a 1/3 contribution to the deposit for the laurels. We never discussed anything to do with the trust arrangement for my grandchildren. Then at paragraph 20, Mr. and Mrs. Thind also say that my investment in the business was a loan, part of which was repaid. I did receive 108,000 business. I did not consider it to be the repayment of a loan. There's then reference to Mr. Thind telling Mr. Gill that Rakesh Patel of Harrison Bernstein, the accountant, said, by taking money out of the business in this way would mean that we did not have to pay any tax. Paragraph 21, as far as we were all concerned, my investment of 133,000 towards the purchase of the laurels was never intended to be a loan. So the pleaded case and the evidential case for the judge here on behalf of Mr. Gill was no, not a loan, an investment. And the investment was the purchase price of 1/3 of a share of a joint venture, oblique quasi-partnership. Well, given that that was the case that was put, that was for decision by the judge, it is wrong, in my respectful submission, to criticise him for choosing between that case and our case, which you've seen incidentally acknowledged that always the case, that the monies put in were by way of a loan, and that the repayments, the vast majority made before the dispute broke out, were the repayments of a loan. And there was no evidence and no suggestion on either side that any equivalent repayments were made to Mr. or Mrs. Thind at any stage. Now, a similar exercise with regard to the £280,000. If your lordship,
would you like to just give us the
I was going to
documents
say,
and the numbers? If I mean, I'm sure that if Mr. Lilly feels that there needs any correction, then he'll comment on it. But just give us the documents.
yes, I will do, my lord. They are particulars of claim, paragraph 5 sub D, which is core tab 17, page 148, and particulars of claim, paragraph 13, capital A, which in the same tab is at 152. And there is one feature of this in 13A. I can read it out, don't need to turn it up if you don't want to, but it is such usual. In 13A, which was by way of re-amendment, the last sentence of 13A on 152, the claimant did this. The claimant distinguished between, split the 280,000. So the last sentence of 13A, the claimant then advanced 200,000 for his stake in the joint venture, and lent a further 80,000 towards renovation costs. So it's a slightly more subtle thing there. It's not all investment. He's saying that 200,000 was investment and the 80,000 was a loan. And his reply on the same topic, para 5.4, supplementary bundle, tab 1, page 7. And his evidence in support of this was in his affidavit, paragraphs 19 to 20, so that's supplemental bundle, tab 4, page 30, and his trial witness statement, paragraphs 32, 34, and 36 to 38. So that's supplemental bundle, tab 11, various points on pages 267 to 269.
So the message that I think you're giving from this is that where the judge distinguishes between a loan and an investment, he wasn't seeking to set up tests for himself. He was simply identifying cases,
yes,
and choosing between them.
Yes, that's the short point, my lord. That once one looks at his judgment by reference to the cases that are up before him, this is there is no proper basis for the criticism. So I've dealt with our skeleton argument 58. I've already dealt now with 1 and 2. 58.3. We refer to common sense approach to the word investment, and we submit that a person making an interest-free loan out of familial affection is not an investor making an investment. And the Oxford English Dictionary is there if you need the tab 25. The point about familial affection, although the loans were formally to the companies JEL and Watts Healthcare, as the judge pointed out at the consequentials hearing, so this is supplemental bundle tab 16, page 374. Now this is the stage in the consequentials hearing where my learned friend is making his oral application for permission to appeal. So that's the context. But on page 374, just below letter D down to letter G, the judge makes the point that the loan was to Mr. Gill's daughter effectively. Yes, in form it was a loan to a company, but in substance it was for the daughter, and there was clear evidence from the Thinds that they did not need the money. So that's why we contrast an interest-free loan out of familial affection with anything normally to be described as an investment. Now, I doubt that your lordships are going to be agonising about Mr. Justice Marcus Smith's judgment in White against HMRC for the purposes of resolving this case, but I am concerned that I simply make a couple of points clear. If you were to decide that the case ought to be read, might I respectfully suggest that the reading of this should be held to, of the head note, paragraphs 37 to 39, 45, 47, 51 to 53, and 54. And the two submissions that I will make orally are simply these. First, it is a non sequitur to say that any loan made by someone other than a company operating a money lending business is always to be described as a capital investment. Simply doesn't follow from that case. And rereading the skeleton argument for preparation, if you have my skeleton argument, it's technically a footnote to 58.4, but it's internal page 16, bundle page 74. There's quite a long footnote dealing with White, and I was concerned rereading it that it didn't entirely make the point I'd been seeking to make. Could I therefore invite you to treat the footnote as not ending with could properly be called investments at all, but add these words, I hope the transcript will suffice, just because on the facts at 285D to E of the report, the upper tribunal chose to describe the inter-business loans as, quote, investments, close quote. Judges' words in a judgment are not to be equated to statute and construed narrowly. And that's Volpe, paragraph 2, Romans 6. Thank you for your patience. In return, I will immediately move on. So then, nothing to add to skeleton 58.5. Skeleton 58.6 about the register of members. As my friend effectively acknowledged in his submissions, the register of members, which was drawn up many years later in 2019 as was common ground, actually records the amount agreed to be paid for the shares. There was no evidence that adduced that £100 was actually paid for the shares. And if one looks at what Mr. Gill said in the supplementary bundle at page 263, paragraph 17, tab 11, page 263, he said, in fact, I only became aware that I held 100 of 300 shares in JEL when Mr. Thind visited me with an option agreement to sign in or around 2011. So insofar as there is evidence which one can draw an inference either way, the idea that Mr. Gill actually paid out £100 so that the shares became fully paid up shares is fanciful. There was no evidence of that in any event. Beyond that, comes that when we do ground 4. So then we have ground 3. That's in 2 parts. We've got the for the moment point, and then we've got the island hopping. Now, the for the moment point, I've shown you these paragraphs in the judgment already, so I must just remind you of the phrases. The judge at paragraph 102 used the phrase not entirely clear. Twice I have to ask my friend to read the word entirely. Not entirely clear. And at paragraph 139, the phrase tends to suggest. And we deal with this initially at paragraph 67 of our skeleton, which I hope puts the matter on a fair basis. That the judge's finding was, even though he could not quite put his finger on what Mr. Gill meant by this hint or even threat, perhaps, that the position might change. So, firstly, there are short references, and I wasn't going to show you Mr. Thind, although I'm conscious of the point Lord Justice Jackson just drew to my attention. But if I can show you Mr. Basu and Mrs. Thind on this, the judge made the point that neither of them were challenged on the phrase for the moment. There was, the substance of it is the same. There's one point in which their recollections differed. So this is supplemental bundle tab 6, page 63. Mr. Basu, paragraph 23, after we'd spoken for a few minutes, I remember Balgett asked Mr. Gill, that was Mr. Basu and Mr. Thind, both thought it was Mrs. Thind who asked the crucial question, or made the crucial statement. Mrs. Thind, as you'll see in a moment, thought it was Mr. Basu. Beyond that, you'll see that it doesn't matter. Asked Mr. Gill whether they could buy him out of the value of the shares. She said that the shares in Jeeves Estates were held for the grandchildren. Mr. Gill responded for the moment. Mr. and Mrs. Thind disagreed and repeated, and so forth. Then on tab 9, at page 233, I'm sorry, we have paragraphs 172 to 3 of Mrs. or 171 to 3 of Mrs. Thind's statement. 173 of the crucial is the key one. To the best of my recollection, Ori, so that's Mr. Basu, asked my dad something along the lines, what are your intentions? What do you want to do? Ori reminded my dad that the shares in Jeeves Estate were for the grandchildren. The thing that sticks in my mind is that Dad reacted sharply and angrily. He said the shares of the grandchildren for the moment. So these 3 points. First, this is a conversation taking place 12 years after 11.5 years, not to exaggerate, after Mr. Gill had agreed to hold the JL shares on trust for his grandchildren, and after relations had broken down at the beginning of 2018. That's our skeleton, paragraph 66. Second, and I can assure you I'm not seeking to improve on the various formulations that my lady and Honourable Justice Jackson put to my friend in testing this point, but I hope this fairly summarises. It is perfectly possible for a person at the same time both to acknowledge that they are holding an asset on trust and to seek or threaten to depart from it, even though the latter is not possible in law. And this is why I mentioned earlier that I was going to come back to the case of Ong and Ping, because there's really rather a striking example of exactly this point in that case. If we can go, please, hit Authorities tab 15 for paragraph, page 216 of the bundle, paragraph 31 of the judgment. Now, the background here is that the property that was purchased in January 1986, and the trust document and the correspondence took place between then and April 1986. And I go straight then to paragraph 31 of the judgment. The final letter I must refer to was written over 2 years later, on the 16th of May 1988. It was from Madam Lim to Mr. Gore of the solicitors who'd been acting for her, and was headed 39 Sheldon Avenue. She wrote, "I refer to the above matter. I would like to cancel the trust dated the 14th of December 1985, created for the following beneficiaries. Please note that the cancellation will take immediate effect on receipt of this letter. Your kind attention and prompt action in the above would be much appreciated." Now, if we can go on, please, to paragraph 36 in the Court of Appeal, so that's bundle page 218. Sir Colin Rymer cites from the judgment of first instance of Mr. Justice Paul Morgan, and the first instance judge, this is the last 4 lines on page 218, dealt with the matter in the 16th of May letter in this way. Sorry, I should have mentioned one point of law. Some of you know how to appreciate this already. Because the subject matter of the trust was land, and because the signed document did not have the schedule of the land filled into it, a point arose about whether there was sufficient documentary evidence to satisfy section 53 of the 1B, I think it is, of the Law of Property Act. And in this context, the letter is signed by Madam Lim, and it refers to the house and the trust. The court can admit evidence to identify the trust referred to in the letter as of the trust deed executed by Madam Lim and Ping. Although the letter of the 16th of May 1988 stated that Madam Lim would like to cancel the trust, the statement recognised that the trust existed at the date of the letter and prior to the proposed cancellation. So there's Madam Lim, who in fact, as a matter of law, was unable to get out of the trust she had entered into 2 years earlier. Nevertheless, by the very letter by which she sought to cancel it, she provided on the Court of Appeal's finding the evidence of the existence of the trust that satisfied section 53. And at paragraph 62, page 225, Sir Colin Rymer, with whom the other 2 judges of this court simply agreed later on the same page, endorsed Justice Paul Morgan's view. He was concerned that an earlier document might not satisfy section 53, that said at 62, if that reservation is justified, I consider that Madam Lim's later letter anyway provided sufficient proof and manifestation for section 53. The judge also placed independent reliance on his letter. I agree with what he said there. So in my respectful submission, insofar as one is to read for the moment as indicating an intention to depart from his obligations as trustee, and that may or may not follow, as I think my Lady Justice Asplin formulated, what if he simply didn't want to be the trustee any longer? That would be another explanation worth. Even if the basic tenor of them is what my friend wants, which is to say, indicate that he felt himself free to cancel the trust, well, so did Madam Lim by writing that letter. Yet the very letter she wrote evidenced the existence of the trust. In my respectful submission, the judge's finding about the for the moment comment was very far from the sort of finding that no rational judge could make in the circumstances or anything of that nature. And the reality of it is, stripping away the more refined legal view of it, the obvious response to what was put to him by either Mrs. Thind or Mr. Basu in the meeting of the forum was one way or the other to deny it. This is a man who knew what a trust was, and what there wasn't was a denial. So then the second limb of ground 3 is the island hopping, the bundle of 5 points. The first is the portfolio summary sent 4th of July 2017, which the judge deals with paragraphs 94 to 95. The fact that the judge deals with 94 to 95 is, in my respectful submission, a quite sufficient answer to the submission, paragraph 48 of my friend's skeleton, that he failed to take it into account. My friend doesn't mean he failed to take it into account. My friend means he didn't reach the conclusion about it that my side would have liked him to come to. It's not the same thing as failing to take it into account. As we submit in paragraph 71 of our skeleton argument, the appellant's case really amounts to saying that you should treat Mr. Basu's tentative recollection set out in the document as compelling evidence of what was actually said. And that, in my respect, submission takes it far too far. It's tab 33 in the supplemental bundle. It's page 420, towards the bottom for the bit my friend likes. It's a qualified statement saying, if I remember correctly, these shares are not held on trust. Is that correct in red print? Question mark. That is hardly a definitive statement by Mr. Basu of what was and wasn't said on the topic. It's qualified by the first 4 words and the last 3. There only is a line and a half of it. It's also striking that in the section on Simicare, which starts on the previous page, but the relevant comments at the top of this one, are the shares held in a trust by Mr. Gill on behalf of the kids? Question mark. Open question. Do you have any trust documents to this effect? Question mark. Well, if Mr. Thind, that would have given Mr. Thind the power, if he'd read it and been conscientious about it, a powerful incentive to reply to that. And we know to reply to that in respect of a trust which did exist. Equally, 8, Jeeves Investments Ltd, top of 421. Jazz is the sole director and the shares are held jointly by BK and BS Gill trustees. That phrase comes from a document that was lodged at Company House. We need to review the trust documents at some stage in the near future if anything needs attending to here. Well, their one was that Mr. Thind had every incentive to go back and say, oops, well, I don't think there is a trust document. Can you help it? Can you help us? Or to do something, both in respect of trusts that we know did exist. So to fault the judge for an irrational conclusion that with no response at all from a man who, generally speaking, is not enthusiastic about paperwork, to put it mildly, is, in my respectful submission, is just the sort of point on which, depending on the overall context and impression of the two people and so forth, trial judge has to make up his or her mind. And I mean, the judge can hardly be accused of being unduly kind to Mr. Thind. He made strong and harsh findings about him. So, nevertheless, the same judge acknowledges that Mr. Thind was somebody who generally was not enthusiastic about paperwork. There really isn't much in this one. The second point is about 2 tabs further on, an email to the Royal Bank of Scotland in February 2018. The purpose, again, as it said at 52 in the friend's skeleton, the judge failed to take it into account. He didn't. The judge dealt with it, paragraphs 98 to 100. My friend's real complaint is he didn't include it as a point helping me in my favour. We deal with this paragraph 72 of our skeleton. I simply draw to your attention that the second page of the document shows that its function is to encourage the bank to offer funding to the Thinds about a proposed purchase of a hotel in Scotland. So that's the function of it, to encourage them to make a loan offer to the Thind family, and it gives a summary of the cases, the other companies they're involved in. Yes, in respect of Simicare, it expressly mentions trust, their trust. In respect of Jeeves Estates, it doesn't, and it doesn't mention Jeeves Investments Ltd at all. Again, this is the trial judge's job to weigh up this sort of stuff in the context. Third point of 5. Mr. Thind was unaware at the time that the accountants had transferred the shares in Laurel's nursing home into JEL, so Laurel's nursing home became a subsidiary of JEL. The judge noted at paragraph 16 of his judgment the dating of the transfer, which came from an annual return subsequently sent into Company's House. And at 17, he missed the point, he then pointed out in paragraph 17 that the issue of the 100 shares to Mr. Gill happened after, we were both the 27th, so it was 9 months exactly after LNH had become a subsidiary of JEL. So the fact of the share transfer and so forth is not a matter in dispute. It's not a matter of fact in dispute. Sorry. We mentioned in our skeleton argument, paragraph 73, the evidence given by Mr. Thind on this, which the defendant says should have been counted against the respondents. And I suspect this level of detail will not be wanted, but we do say that the 3 propositions in 73 are a fair summary of the evidence given in cross-examination by Mr. Thind, starting on page 68 and ending on page 73 within the bracket set in footnote 36. So the judge did clearly understand this point, and the fact that he didn't go on to give a particular commentary on his reasoning about this, in my respectful submission, it's just one example of the point made both in the Phage case by Lord Justice Lewis in paragraph 115 and in the Sprint Room case, paragraph 85, that a judge does not have a duty to deal with every argument every argument presented, and to deal with, in particular, at any length, which matters are not in dispute. There can't, in my respectful submission, be any proper criticism of the judge's account of this at paragraphs 16 and 17. Similarly, at paragraph 29, apart from another typo, which I'm ashamed to say that none of us in this part of the court noticed at the time, there can't be any other criticism of what the judge said in paragraph 29. In the third line, it should say on the 1st of November 2014. That was based on a particular document. That's the date my learned friend has been using. It was 2014.
Yes.
There was nothing, in my respectful submission, in respect of this point, which is obviously later event, that particularly assists the matter, and the essence of it is that, as we say in paragraph 75, based on Mrs. Thind's evidence, that as the business was regarded as all part of Jeeves Estates, the fact that it was taken in to JEL and therefore was something that the grandchildren had a 1/3 beneficial interest in is not inherently greatly more or less likely than what doing that if Mr. Gill was the beneficial owner. Indeed, given the judge's finding that Mr. Gill was not part of the joint venture in Watts and advanced the 280,000 in its many tranches as a loan and was repaid nearly all of it, offered the last 30,000 with pleadings, if anything, the natural likelihood is less on that basis than if it had been for the grandchildren. So my respectful submission, that one again, there's nothing compelling, nothing the judge has failed to take a point that any reasonable judge would have taken, or anything of that nature. Point 4 or 5 is that none of the grandchildren were told by Mr. Gill that he was holding this on trust. We deal with that 76 to 78 of our skeleton argument. Just for a quick review of who the grandchildren were, the Kaler children were the eldest, but they lived in Canada, and there was specific evidence from Mrs. Thind, as well as her husband, that at the time of the £133,000 loan, her father specifically asked her and her husband not to mention it to Mr. Kaler, because if you did, Mr. Kaler's going to ask me for a loan too. So as that was Mr. Gill's own approach, there's nothing surprising that he wouldn't be sharing with the Kaler's children the arrangements in respect of the business being run by the Thinds. So far as the two English grandchildren are, male grandchildren are concerned, Avnish and Jeeves, we deal with that at 77.3 and 4, and in particular, going back to our respondent's notice point 1, it's a bit rich to say the judge should have held against us that Mr. Gill didn't tell Avnish, when actually what Mr. Avnish's evidence was that his grandfather did tell him more than once. And as to the Thind's third child, their youngest child, Simran, the judges accepted evidence, paragraphs 44, sub 13, sub B, 117 and 119, that she was someone who suffered from anxiety and depression, whose parents were very anxious to protect her from stress and so forth, and the judge specifically accepted that, supported by evidence of Mrs. Thind as well as Mr. Thind. The Benning children were much younger, as the chart we've supplied shows, but their mother was told. That goes back to the WhatsApp message, which is the respondent's notice point 2. So in my respectful submission, it's a pretty weak supporting point when one looks at who's actually involved. And the no contemporaneous documents point was in the grounds. It wasn't developed in skeleton argument or orally, so I'll simply rely on what we say in our skeleton argument at paragraph 79 to 82. So to take stock, ground 1, in my respectful submission, on the facts found by the judge, he was perfectly entitled to reach what is ultimately the factual finding that an intention to create a trust was evinced, and therefore the trust was created when the transfer took place. And if you were against me on that without the respondent's notice, then I rely on the respondent's notice matters already. If you're against me on that completely, we would go straight to ground 2. Ground 4, the resulting trust. Otherwise, we have grounds 2 and 3. A friend's summary of what the position was if he lures you into finding for him on one or more points under grounds 2 or 3 is that therefore the judgment would be unsafe. Well, that's all right in itself, but it doesn't face up to the question that would then follow. Are the circumstances such, in a case of evidence of this scope, that you could substitute your own finding, or, God forbid, would it require a retrial? In any event, you would look no doubt at ground 4 first, before considering that unbelievably unattractive option. Which leaves me only now with the question of resulting trust for Mr. and Mrs. Thind, the judge's alternative basis. And the starting point for that is the judgment at 124 sub 2. Sub 1, 124 is the judge saying the findings that he's got to make. And 1241 is express trust. 1242 is resulting trust. And in respect of that, he cited the case of Vanderbilt, which I had originally asked to be included in the authorities. It's certainly been provided electronically. If your lordships have hard copy files with you, I can have that passed up. The short point is that Vanderbilt is an entirely appropriate authority for the judge to have used for the basic principles with regard to resulting trust, and in particular that at 312 between D and E, they're paginated to go in the back of the hard copy bundle. He's begin with really the one point that's live here. Between D and E on 1312, where A transfers or directs a trustee for him to transfer the legal estate in property to B otherwise than for valuable consideration. It is a question of the intention of A in making the transfer, whether B was to take beneficially or on trust. And then there's a next page and a bit is cited by the judge, and indeed the report goes on, lower part of 313, to consider the other sort of resulting trust, which my friend mentioned. As on the face of it, a resulting trust arising from failure to exhaust the beneficial interest doesn't, unless I've missed some subtle point, appear to me to arise on these facts, so I won't take any time on that. So the judge has started by approaching this with a proper reference to the law that he was applying. So then, this is the last page of our Scales argument, internal page 25. The point we make at 94 and 95 is, I hope, an important one. The judge has held us that Mr. Gill provided no consideration for the shares, and there was no basis for inferring that Mr. and Mrs. Thind intended to make a gift of the shares. Now, in terms of nominal consideration, valuable consideration, and so forth, the case of Preston Petrodel, the key paragraph is 49, so that's tab 12 at page 156 in the authorities. And if I simply tell you without taking time to read them through, the underlying facts that are being summarised here can be found on page 154, paragraph 46, and page 155, paragraph 47. The husband in that case had caused 5 properties to be acquired by the company PRL, and in each case, starting three flats in London, each for a nominal consideration of £1, which Lord Sumption goes on to equate with a gratuitous transfer, and this is the ratio decedenda of the case, that the one was ultimately successful, not on 2 other more legally far-reaching grounds, but on the grounds that a lot of the property she was after was in fact held on resulting trust for her husband, and therefore part of the matrimonial cake, if I may put it that way. I'm well aware that others in the room will be very familiar with it. But it's a point with which the other 6 judges of the case all agreed at the references we give in the footnote. So the question that there arises is, does my friend have a knockout point because the shares were not first vested in the Thinds and then transferred by them into his client's name, rather they were allotted direct from him, from the company to him. The company being issued at this under the control of the Thinds. Now, the Shepherd and Cartwright case, which is at tab 1 of the authorities, was, as my friend drew to your attention correctly this morning, a case where it was found on the fact that the Mr. The father of the children had yes, it was Mr. Shepherd, caused the shares to be allotted to children of his, but they were paid up shares, and the father had paid the par value of the shares into the company. So they were paid up shares. Subject to that point, the key passage is on page 9, report page 445. I do not distinguish between the purchase of shares and the acquisition of shares upon allotment. And I think that the law is clear that on the one hand, man purchases shares and they're registered in the name of a stranger as a resulting trust in favour of the purchaser. It goes on to contrast position where the recipient's a child and therefore the presumption of advancement applies. Now, there is no evidence that either the Thinds or Mr. Gill have paid the subscription money for those shares. So they may well be unpaid up shares, certainly at all material times, unpaid up shares. So if one looks at the possibilities in those circumstances, it is not a case where Mr. Gill can say, well, there's no resulting trust because I paid for these shares. Therefore, the case that my friend then went to, which is our second authority on the point, fan mail, develops this point rather more fully and much more subtly. The at page 114, paragraph 199, the last sentence of the paragraph, both sides submitted that the ownership of the shares falls to be determined as at the time they were originally allotted. So that is the date upon which I focus in this judgment. Then between 200 and 202, the judge accepts that Shepherd and Cartwright was a case where the shares were paid up, and that in that respect it doesn't cover the present case. That's the conclusion at 202. Whereas in this case, if somebody is the registered holder of a share which is not paid up, they owe in principle a debt to the company. The company can call for the shares to be paid up at any one time. So in particular, if the company goes bust and doesn't meet its liabilities, the company can require the shareholders to put in that amount of money. So 203 is where the judge, now Lord Sales, moves on to the position in the share where the, by definition, the person who's had the shares, accepted the shares registered in his or her name, has a potential liability of £1 per share. Now in that case, he described it as de minimis, so he's not nominal, but de minimis. But the obligation to pay £1 per share would equally be the extent of the obligation of Mr. Gill on these facts. And then rapidly, my Lord Justice Arnold descended on the third sentence of paragraph 205, which is where Mr. Justice Sales proposes the correct approach, and my submission is that is what the judge did at paragraph 145 of the judgment in this case.
Yes.
And really, it's as short a point as that, because the other aspect of it, the last sentence of 145, goes back to the point about no capital investment, etc., which is already dealt with in ground 2. Lord, not my best. Subject to any questions you may have.
No, thank you very much indeed.
Can I just have one more?
Of course.
Oh, I'm grateful. Yes, I'm grateful. It goes back to my Lord Justice Jackson's question. You directed us to paragraph 11 of Mr. Gill's strictly affidavit, which generally calls his first statement.
Yes, you then went,
SB
you went back to that, didn't you?
Yes, that is the same topic it's dealt with in his trial witness statement, paragraphs 10 to 14. That's reference supplemental bundle, tab 11, pages 261 to 2. Very grateful to Mr. Mundy for digging that out while I was
Thank you.
Thank you.
Yes, any reply, Mr.
Well, yes, just a few very short points.
By all means.
My lord, my learned friend, in advancing his arguments in relation to the first matter, which is whether this is ground one as an appeal of fact or law, referred to the judgment of Lord Hoffman in Carmichael. And I would just appreciate if your lordships and ladyship could turn that judgment up. It's at tab 6 of the authority bundle, starting at page 57 of the bundle. Now, my learned friend took you to the paragraph at B and C, where Lord Hoffman observed that the Court of Appeal pushed the rule about construction of documents too far, and noted that in a case where the intended terms of the contract extend beyond just the written document, the terms of the contract are a question of fact. Now, first of all, I draw your lordship and ladyship's attention to the fact that it is not the construction of the terms which he says is a question of fact. He's saying that the actual ascertainment of the terms is a question of fact. And to expand upon that, over the page, at page 58, at little b, you'll see that he goes through an explanation of effectively what the first instance court did. And in that case, the industrial tribunal found that the written document did not contain the totality of the contract, and that was the party's intentions. And at little c, Lord Hoffman goes on to say that it was open to the industrial tribunal to find that as a matter of fact, the parties did not intend the letters to be the sole record, and that it should be contained partly in letters and partly in oral exchanges. So that is a question of fact. So then, in the next paragraph, just about after little d, it was on that basis that when it was appealed the first time to the Employment Appeal Tribunal, Lord Hoffman agreed that they were right not to interfere with that decision of fact, i.e. the decision that the parties intended the contract to not just be in the letters, but extend beyond that. In the same paragraph, just above F, he then records what the Court of Appeal held. And you'll see there that Lord Justice Ward said that it was a mistake because the terms of the contract must be objectively construed, and what they, that is the parties, thought they had achieved is of no consequence. And Lord Justice Chadwick likewise said that the question was not what the parties thought their obligations were. In other words, what the Court of Appeal did is they interfered with the Industrial Tribunal's decision that the terms of the contract should go beyond just the letters on the basis of a principle of construction. And it was that which Lord Hoffman said extended the principle of construction too far, because the principle of construction obviously applies after you have determined the terms of the contract. And determining the terms of the contract is a question of fact. Now, my lords and lady, I would submit that this actually supports my submission in terms of the way in which this court should approach the matter. Just like the ascertainment of the terms of the contract in Carmichael were questions of fact, the question of what the putative settler, in this case the appellant, said or did necessarily are questions of fact as recorded in the judgment. But after that, it is then a question of construction, which is not a question of fact, it's a question of law. My lords and lady, the next point relates to actually a comment of my Lord Justice Jackson in relation to the JIL and Simicare trusts. And his lordship rightly made the comment that on the face of it, the fact that there were two declarations of trust, particularly the JIL trust, which I believe my Lord Justice Arnold noted was the one that predated the JEL trust, might make it more likely for the court to conclude that there was a trust of the JEL shares. The judge actually, first of all, dealt with this in the judgment at paragraph 137.
Thank
you. And he dealt with it on this basis. He said that it was more difficult to determine the position in relation to Mr. Gill's 100 shares in JEL, because he said, in contrast to the JIL and Simicare shares, where Mr. Gill did not know that he was a shareholder and clearly gave no consideration for the shares, it is common ground that he did receive the shares in JEL and did advance substantial sums in relation to the Laurels and Sherwood, albeit that it's disputed whether these were loans or investments. So, my lords and lady, you'll see that the judge actually specifically made a finding that the position in relation to the JIL trust is different than that of JEL. And therefore, you cannot draw much, I'd say you can't draw anything from the fact that a JIL trust was established in a different factual context from that in JEL.
Well, at all events, whatever one might or might not draw from it, it doesn't appear the judge drew
Precisely, my lord.
the point
Precisely, my lord.
for himself.
Precisely. Just pausing there as well, my learned friend made a comment that effectively this was a bit like a false alibi point, that the forged trustees were forged in relation to trust that actually exists. I make a point. It cuts both ways, because it has always been an oddity, and indeed I submitted this to the judge below, that if indeed Mr. Thind was forging deeds for trusts that actually existed, it is notable that he did not forge anything for JEL. So the position between the two sets of trusts, JEL on the one hand, JIL and Simicare on the other, actually are different. The next short point is simply to just emphasize an issue that was raised by my Lord Justice Jackson when my learned friend was making submissions in relation to Avnesh, Thind, and Mr. Satnam Singh. That there was sauce for the goose, a sauce for the gander, and I very much agree with that point. On ground one, I was very careful to ensure that the facts and matters I relied upon were those
only
that
arises
contained
if you
judgment.
get beyond ground one.
But precisely, my lord, precisely. The ground one points I rely on are contained within the judgment, such as the option agreement, the January email. It is only under grounds 2 and 3 that I then go beyond that. Then just touching briefly on the loan versus investment point, it is absolutely right, and you've seen the numerous references my learned friend has made, that this case was pleaded and the evidence was settled on the basis that Mr. Gill disputed that what he provided was a loan, but instead it was effectively a form of equity contribution. Now, that as a matter of fact was rejected by the judge, but I think it is generated a false narrative that just because that finding of fact was made against Mr. Gill in relation to the loan, it must necessarily follow that it was not an investment. And indeed, my learned friend took your lordship and lady to the points in the judgment, where the judge expressed this as whether it was a loan versus an investment. And my lords and lady, I would say that that is a fundamental flaw. Obviously, the appellant's factual position that it was not a loan was rejected. But that's not mutually exclusive. That doesn't prevent the loan that was found by the judge counting as an investment. Just a brief comment on the parallel my learned friend sought to draw between the comment for the moment and the letter of Madame Lin in the On and Ping case. You'll be able to read the letter yourself, obviously. My simple submission here is that in that case, that letter was a very clear acknowledgement that a trust existed, because it was a declaration of intent to then terminate the trust thereafter. So it was necessarily implied in the comment that a trust had to exist. The same could not be said for the comment for the moment. finally, in relation to ground 4, I just observe in relation to the Van der Velde case that obviously the key point there is that it's where assets are given without consideration. And you heard my submissions earlier in relation to the fan mail judgment. In particular, I rely on the fact that Mr. Justice Sales, as he then was, expressly found that a liability to pay when demanded is a payment for the shares. So this is not a case where there is no consideration. It's also not a case where it's nominal consideration. And indeed, that's why Mr. Justice Sales used the word de minimis and tiny, not nominal. Nominal consideration, as your lordships and lady will of course know, is a term of art. In the authorities bundle, I won't take it to you, but it's at authorities bundle 5, cited in my skeleton. There's a decision of Midland Bank and Green, very well-known decision, where nominal consideration is consideration that is recorded as being given but was never intended to be given. And that is of a different nature, and it's certainly not the way Mr. Justice Sales treated the liability to pay the par value for the shares if DPL demanded it. It's not nominal in that sense. My lord and lady, unless you have any further questions, those are my submissions.
No, thank you very much indeed. May we thank you all. This has been, they say so, very well argued. And we'll take time to consider our decision and let you have our judgments in due time. You will be very familiar, but there'll be others in court who are not so familiar with the regime, which is that you'll receive draft judgments which can be shared strictly with those on the lists, and you'll please provide us with any editorial suggestions, no re-arguments, and a draft order reflecting our decisions. In due course, the decisions will be handed down formally and published, and we won't need to trouble you for further attendance. If there are any issues on the draft order, we'll decide those on the basis of short written submissions filed at the time, please. So we will reserve our decision in what is very obviously a very sad case for this family. Thank you.
All right.
Brilliant job finishing 1 minute to 1. All afternoon I was thinking about, will I piss them off by going to Asplin?
It wasn't intentional, actually.
Ah.